Let's talk about a hearing that could quietly reshape how the jury is going to see Florida versus Courtney Clenney. On Friday, February 20th, the defense walked into Judge Andrea Wolfson's courtroom trying to do two big things: knock out the state's key expert and block a series of secret recordings that prosecutors say show who Courtney really is behind closed doors. They didn't get everything they wanted, but what they did win may be more important than what they lost. Courtney Clenney, known online as an OnlyFans model and influencer, is charged with second-degree murder in the 2022 stabbing death of her boyfriend, Christian Avumsali, also known as Toby, in their Miami high-rise apartment. Prosecutors say this is not a split-second accident, but the end of a violent escalating pattern, and they point to videos, texts, and audio recordings that they claim show Clenney raging, berating, and even physically attacking Avensali before the fatal stabbing. The defense says she acted in self-defense in a toxic, mutually volatile relationship, and that the state is overcharging her and weaponizing her social media persona to make her look like a villain. Friday's hearing was not about guilt or innocence directly. It was about what evidence the jury will even be allowed to see and which experts will be allowed to talk to them. The two major issues that are on the table: whether the state's domestic violence type expert, Dr. Michael Brannon, should be kicked off the case, and whether a series of secret audio recordings made by Abusali without Courtney's knowledge should be suppressed. How the judge ruled on these two questions will shape how both sides tell the story at trial. So let's start with the expert drama. The prosecution has named forensic psychologist Dr. Michael Brannon as their expert. He's familiar to court TV viewers, and he's testified for the state in other high-profile trials. We've heard this name a lot. The defense filed a motion asking Judge Wolfson to exclude Dr. Brannon entirely, and their argument wasn't about his credentials. It was about his history with their expert, Dr. Lenore Walker. Roughly 22 years ago, Brannon sued Walker for defamation. That lawsuit ended in a settlement where they agreed not to disparage each other personally. The defense said that Walker would feel constrained, like she had to soften her criticism of Brannon's work to avoid violating that old agreement. That dynamic creates a conflict and risks confusing the jury with side issues about an ancient lawsuit between experts. At this hearing, both experts appeared, essentially putting their professional relationship on trial. Walker told the judge she is uncomfortable continuing on a case where Brannon is the opposing expert because she feels bound by that old settlement and needs to carefully choose her words. Dr. Brannon, on the other hand, testified that he sees no problem with both of them working on the same case if everyone remains professional. So you have one expert saying, "I feel constrained," and the other one saying, "I'm fine, let's go ahead." Judge Wolfson ultimately denied the motion to strike Dr. Brannon, and that means that Brannon stays in as the state's expert, and Walker is still free to appear for the defense if she chooses. But the judge is not going to re-engineer the state's witness list around a 2-decade-old civilian dispute between experts. And during the actual hearing, which I have linked for you below if you want to hear all the nitty-gritty, Dr. Walker's testimony was basically, well, she had been in other cases with him before and she was uncomfortable. So now she doesn't ever want to do it again. That's her choice. But you don't get to kick the other expert off because you're not comfortable being around them. And the defense even tried the first come, first serve rule, which really isn't a legal rule in court. And prosecution really had a little bit of fun kicking that one out. But anyway, from a strategy standpoint, the state keeps a powerful storyteller to frame the relationship dynamics, and the defense keeps its expert, but with this underlying tension that may still be at play. And now the second issue from this hearing is huge for the emotional tone of the upcoming trial. Christian Abumsali secretly recorded multiple interactions with Courtney Clenney, audio and or video clips capturing arguments, slurs, and her alleged aggression. These were recovered from his phone during the homicide investigation. Prosecutors wanted to play a set of these recordings for the jury to show what life with Courtney allegedly looked like before the stabbing. The defense challenged these as illegal, surreptitious recordings under Florida's two-party consent law because Courtney allegedly did not know she was being recorded in many of them. Their position? Secret recordings made without her knowledge in private spaces violates Florida law. Evidence obtained that way should not be admitted at trial. And well, the judge's ruling was kind of split. She gave a split ruling. So both parties won a little bit here. She suppressed most of the recordings the state wanted to use, agreeing they were inadmissible as illegal, surreptitious recordings because they were private and because Courtney did not know she was being recorded and had an expectation of privacy. Well, she allowed recordings that were made in the lobby of the building and on the couple's balcony because she was finding that there was no reasonable expectation of privacy in both those locations, and you didn't really need the two-party consent. It was out in the open. Those recordings will come in. So the more intimate private audio the state was counting on is largely off the table, but they still have some powerful ambient and location-based clips, like lobby arguments that could show tone, hostility, or fear without the same privacy issues. From a trial watcher perspective, that's a significant win for the defense. It shrinks the universe of Courtney on tape that the jurors will hear, while still giving the state a few pieces to argue about the relationship dynamics. Now let's talk optics, because that has already gone viral, as you may have already seen. Before the hearing formally got underway, cameras caught Courtney sitting at the defense side, making faces into the galley, sticking her tongue out and puckering her lips like she was blowing kisses, to someone actually waiting in the benches of the galley. Those clips were picked up by news outlets and social media, with many viewers reacting to what they see as a light, almost playful demeanor from someone facing second-degree murder charges. In a case where the state is already arguing that she is impulsive and volatile and focused on image, these kinds of moments become part of the narrative, fairly or not. What do you think? Please, I can't wait for you to tell me in the comments what you thought of that. This is how she behaved before a key evidence hearing. I wonder what the trial is going to be like. Do you think she'll play to the audience, to the jury, to the judge? This hearing was just one more step in a long pre-trial process that's been filled with motions to dismiss and bond arguments and discovery fights. And as of now, though, Dr. Brennan will be allowed to testify for the state. Dr. Walker can still appear for the defense despite her discomfort, if she chooses. And most of the secret recordings are out, but lobby and balcony recordings are in. A status hearing is set for March, and trial is currently planned for spring 2026, with April 27th previously set as the start date. Right now, with the state keeping some of its recordings, a handful of them, and its expert, it'll help them tell the story about a chaotic, sometimes violent relationship. But the defense wins a majority of the battle here, with their privacy fight and blocking the bulk of the most intimate secret audio, and they get to argue that the state overreached by relying on illegal recordings. But let's not forget that the jury will never see the motions hearings or what happened on February 20th. Okay, because what happened on February 20th dictates which tools each side will have when the jurors finally sit down and listen. So how do you think it went? I linked the full hearing below from another site, Law in Crime, of course. I like their coverage without commentary. And you can see for yourself the courtroom dynamics and the play of both attorneys off each other with the judge, and even the way the expert witnesses presented themselves, if you want to get involved that deep. I chose to just do a recap because there just was so much I wanted to say. And I want to hear what you have to say. Do you think the judge did a fair ruling here in regards to the recordings? Also, I should mention that the judge said that, well, they may actually seal on the other recordings so they don't get leaked, which would be a good idea because we don't want them everywhere. We'll see it all. And then the jury could get tainted. We wouldn't want that. We want to stay on track for a trial in April. So meet me in the comments. I can't wait to hear what you have to say about this one because, wow. Let me know what you think if Courtney Clenney has done anything with that little routine she pulled during the hearing. What was that all about? Anyway, please don't forget to like, share, and subscribe if you like the content so you get notifications of when the next video drops. Liking and sharing really helps keep things going here. But please, meet me in the comments. I can't wait to hear what you have to say about this one.